Before I joined the HR department at Shopify's Ottawa office, I spent 3 years as a benefits coordinator for a mid-sized insurance brokerage. I knew every clause, every loophole, every trick employers use to deny coverage. I knew how to read a policy document the way other people read a text message, fast and between the lines. My husband never knew that about me. Or maybe he did, and he just didn't think it mattered. He was wrong. I met him at a friend's cottage on Ratto Lake the summer I turned 27. He was charming in that specific way that cottage weekends produce, relaxed, sunburned, laughing easily. We dated for 2 years, got married in a small ceremony outside Kingston, and by the time I was 30, we had a daughter named Isla and a semi-detached in Barhaven that we'd bought together. My down payment slightly larger than his. Something I never made a thing of because it wasn't supposed to matter. I left my benefits job when Isla turned 1. The daycare waitlists in Ottawa were insane. We were looking at 18 months minimum for a licensed spot near our neighborhood, and the math didn't work in favor of me going back right away. He made more. It made sense on paper. I told myself it was temporary. Temporary turned into 4 years. Isla developed a speech delay around age 2. Nothing catastrophic, the pediatrician said, but significant enough that she needed speech-language therapy twice a week. The SLP we found through Chio's referral network was excellent. She had a quiet office near Westboro, flashcards everywhere, a way of making Isla feel like they were just playing. The sessions weren't cheap, $180 each, not fully covered under my husband's benefits plan, which had a $400 annual cap for speech therapy. We burned through that in just over a month. I asked him if we could look at topping up the coverage. He said he'd look into it. He never did. I paid out of pocket. I kept every receipt in a folder on my desktop, organized by date, because that's the kind of person I am. Then came the October evening when I found the texts. He'd left his phone face up on the kitchen counter while he went to get Isla from bath time, and a message came through from a contact saved only as J. Not a name, just a letter, which told me everything before I even read the words. I read them anyway. I wish I could say I confronted him that night. But I didn't. I stood there in the kitchen while the dinner I'd made sat cooling on the stove, and I thought, I need to think before I say a word. I put his phone back exactly where it was. The next morning, after he left for work and Isla was settled with her coloring books, I called a lawyer. Her name was not important to the story, but her advice was, she worked out of a small firm on Elgin Street, the kind of office with too many file folders and a window overlooking a coffee shop, and she had a calm, methodical way of laying out exactly what I was facing. She told me that in Ontario, the matrimonial home, regardless of who put in more for the down payment, was subject to equalization of net family property. She told me that any assets he had coming into the marriage or inherited during it could be excluded. She told me to start gathering documents, quietly, without alerting him. I already knew how to do that. He had a small incorporated business on the side, a consulting thing he'd started 2 years before, technical writing contracts for a few government clients. He'd always been vague about what it earned. Not much, he'd say. Barely worth the paperwork. I had never had a reason to push back on that. Now I did. I pulled the last 3 years of our joint tax returns from the filing cabinet in the spare room. I made copies. I went online and looked up his business registration through the Ontario Business Registry, which is public record. Anyone can do it. I noted the registration date, the address, the structure. I still had contacts from my insurance years, including one woman who'd moved into forensic work and occasionally consulted for family law firms. I called her. I explained what I was looking at without using names. She gave me a list of things to watch for. He came home that evening, and I made pasta, and we watched something on Netflix, and I said nothing. I was running the numbers in my head the whole time. A few weeks later, he told me he wanted a separation. He said it gently, like it was something he'd been agonizing over, like he was doing me a kindness by being honest now. He said we'd grown apart. He said he wanted to be fair. Within 2 weeks, he had moved into a rental near Hintonburg. Convenient, I noted, for the address I'd found connected to Jay, and a letter arrived from his lawyer outlining his proposed division of assets. The proposal suggested that since his business had minimal value and he had significant debt associated with it, the equalization payment should be modest. He'd run the numbers in a way that left me with the house and roughly $60,000. He was keeping his RRSPs, which he'd been maxing out for years while I hadn't contributed to mine because I'd been out of the workforce. He offered to pay child support at the table-based amount for Ontario. I read that letter 3 times. Then I opened the folder on my desktop. Here's what I'd found by then. His consulting corporation had been billing a consistent $50,000 to $60,000 a year in contracts. Not nothing, not barely worth the paperwork. The T2 corporate returns, which I'd found in a filing box he'd stored in the basement and apparently forgotten about when he packed his things, showed retained earnings that hadn't been disclosed in his personal tax situation in any obvious way. The money was sitting in the corporation, not drawn as salary, not reported as dividends, just sitting there, growing, while we budgeted carefully for Isla's speech therapy, and I told myself the $400 cap was something we'd deal with later. There was also a line in one of the older returns for a capital cost allowance on equipment I'd never seen. A laptop I didn't recognize, a camera setup. I thought about that for a while. I contacted my former colleague. She connected me with a chartered professional accountant who specialized in family law valuations. He worked out of a firm in Nepean and had the energy of someone who genuinely enjoyed untangling financial knots. He reviewed everything I'd gathered and told me, in measured terms, that the picture being presented by my husband's lawyer was materially incomplete. I brought this to my lawyer. The next letter our side sent was different in tone. My husband's lawyer requested a full financial disclosure process as is standard in Ontario family law. He was required to produce a Form 13.1, a sworn financial statement. He produced one. His accountant prepared it. It listed the corporation's value at $12,000, citing outstanding liabilities and low equipment value. My accountant looked at it and shook his head slightly. "The retained earnings alone," he said, and then he paused and wrote a number on a notepad and slid it toward me. It was not $12,000. There were 3 months of back and forth. Letters between lawyers. A case conference at the courthouse on Main Street East, where his lawyer was confident, almost dismissive. My husband sat across the table from me and looked at the surface between us and not at me. He'd hired someone good, a senior partner at a firm with a polished website and a parking garage. At the case conference, our side raised the valuation discrepancy formally and requested a full third-party business valuation. His lawyer objected to the cost. The judge, a woman who had clearly seen this particular movie before, ordered it anyway. The valuation came back 5 weeks later. The retained earnings in the corporation, combined with a shareholder loan he had made to himself that had not been repaid and had not been disclosed in his sworn statement, put the business value significantly higher than $12,000. High enough that the equalization math changed considerably. High enough that his lawyer's posture at our next court date was different. More careful, less assured. But that wasn't the part that I think about the most. At some point during those 3 months, while our lawyers were writing letters and I was putting Isla to bed every night and explaining in age-appropriate terms that Daddy lived somewhere else now, but that she was loved, so loved, more than she could understand, he removed Isla from his employee benefits plan. I found out when I went to submit a receipt for her speech therapy session and the claim came back denied. Coverage terminated. I called the insurance company. They confirmed the policyholder had removed the dependent as of 30 days prior. She was 4 years old. She was in the middle of a course of treatment that her clinician had specifically outlined as time-sensitive for her development. And he had removed her from the plan. I documented everything: the denial letter, the date of termination, the clinical notes from her SLP indicating the ongoing necessity of treatment. I paid out of pocket for every session and kept every receipt. My lawyer added it to our materials. At the next court appearance, when his lawyer was making an argument about his limited financial resources and the burden of the proposed support amounts, our side presented the benefits termination. The judge looked at the documentation. She looked at the date, 30 days after his sworn financial statement. the one that had dramatically understated his assets. She looked at him. She asked him directly whether he had arranged for alternative coverage for his daughter. He had not. What followed was not loud. It wasn't dramatic in the way courtroom scenes in films tend to be. It was quiet and thorough, which is somehow worse if you're on the receiving end of it. His lawyer asked for a brief recess. When they came back, the tone was different, conciliatory. They were prepared to revisit the financial disclosure. The revised equalization payment, when it was finally calculated on accurate figures, was more than 3 times what his original letter had proposed. Isla was also added back to his benefits plan by court order, retroactive to the termination date. The cost of every session I had paid for out of pocket during that period, everyone I had documented, was reimbursed. He was required to maintain benefits coverage for her until she was 18, or until she was no longer a dependent under the policy terms. He was also required to contribute to a registered education savings plan for her going forward. His lawyer's parking garage firm did not appear at any further proceedings. He switched to someone more junior. I didn't feel triumphant when it was over. That's the part that's hard to explain to people who ask how it felt. I felt tired. I felt the particular kind of exhausted that comes from holding something together, carefully and quietly, for a very long time. I felt it most on the drive home from the final appointment, when Isla fell asleep in her car seat on the 417 and the Ottawa River was flat and dark on my left and the city lights were just starting to come on. I thought about the years I'd taken off, the RRSP contributions I hadn't made, the career progression I'd stepped away from, the down payment that wasn't supposed to matter but did. I thought about the folder on my desktop, organized by date. I thought about the fact that I had spent 3 years learning to read insurance documents, and that no one had thought to ask me about that. I got a job offer the month before the final settlement. The firm I'd done some freelance contract work for during the proceedings, they'd seen how I worked apparently, offered me a role as a benefits compliance analyst. Good salary. Flexible hours. Benefits plan. I understood line by line. I accepted. Isla's speech has come a long way. She talks constantly now, which her SLP says is a very good sign and which I find both wonderful and exhausting in the best way. She asked me recently why our house only has 2 people in it when her friend's house has 4. I told her that families come in lots of different shapes and that our shape was exactly right for us. She seemed to think about this for a moment. Then she asked if we could get a dog. We are currently on a wait list. There's a version of this story where I come out looking like someone who planned everything perfectly from the start. I want to be honest, I didn't. I was scared for most of it. There were nights I sat at the kitchen table after Isla was asleep and just stared at the folder on my desktop, wondering if any of it was going to be enough. What I had wasn't a plan. It was a habit. The habit of paying attention, of keeping records, of understanding the documents that crossed my path. I built that over years, quietly, in a job most people find boring. And when everything fell apart, that habit was the only solid thing I had to stand on. I think about cause and effect a lot now, not in any grand spiritual sense, but in the plain, practical way that life tends to work. He spent years making small choices, billing through a corporation and not disclosing it, letting Isla's therapy receipts pile up while the money sat elsewhere, and finally, removing a 4-year-old from a benefits plan mid-treatment because he calculated it would cost him less. Each of those choices was its own decision. Each one left a document trail, and document trails, it turns out, are exactly what I know how to read. I'm not saying he got what he deserved in some cosmic sense. I don't know how to weigh that. What I do know is that the outcome was a direct result of what each of us had actually done, not what we'd said, not what we'd claimed in sworn statements, but what the paper record showed. That felt fair to me. That still feels fair to me. What carried me through wasn't anger, even though I had plenty of it. It was something quieter, a commitment to doing this right, not just for myself, but for Isla. I wasn't going to let her lose her therapy coverage and just absorb it. I wasn't going to sign documents I knew were inaccurate, because the process was exhausting, and the other side had a better-funded lawyer. I kept going back to the same thought. She's 4 years old, and she's learning to talk, and she deserves someone in her corner who doesn't give up when it gets hard. That's the part I'd want anyone in a similar situation to hold on to. Not the legal specifics, those vary, and you need your own lawyer, your own accountant, your own advice. But the underlying thing, the willingness to understand your own situation fully, to gather information instead of accepting the version you're handed, and to keep moving forward even when the process is slow and expensive and emotionally draining in ways you didn't anticipate. Intelligence without the nerve to act on it doesn't get you very far. And nerve without the knowledge to back it up doesn't either. What works is both, together, sustained over time, even when you're tired, even when the other side seems more powerful, even when you're doing it all while making dinner and explaining to a small child why the house feels different now. Isla asked me last week if I was happy. I told her yes, which is true, in the complicated way that real answers usually are. She thought about it for a second and then asked if the dog would also be happy when it arrived. I told her I was pretty sure it would be.